Honourable member for Saanich Gulf Islands.
Merci, Monsieur le Président. C'est un honneur pour moi de prendre la parole aujourd'hui pour parler sur le stage de rapport du projet de loi C-75, loi modifiant le code criminel, la loi sur le système de justice pénale pour les adolescents et d'autres lois et apportant des modifications corrélatives à certaines lois. C'est un projet de loi omnibus sur les questions des lois criminelles au Canada. Et au début, je pense que tout le monde qui s'occupe avec ces questions, ces enjeux importants de justice dans notre société sont vraiment positifs avec les mots de la ministre de Justice, parce que c'est évident que nous avons besoin de réformes. Malheureusement, les espoirs de plusieurs des avocats, plusieurs des personnes dont la société qui exige pour les vraies réformes sont déçus. There is a great sense of disappointment. The longer we work with Bill C-75, the more the disappointment deepens. Michael Spratt's been quoted in this debate before, the former chair of the Canadian Criminal Lawyers Association. But as he put it, quote, "It all sounded so good, but it has all gone so wrong." Well, I did attempt to make improvements to the legislation. Members of this place will know that while my status as leader of the Green Party of Canada does not allow me to sit on any committees, through the work of the PMO, first under former Prime Minister Harper and now under our current Prime Minister, I have some might think of it as an opportunity. I have to say, Mr. Speaker, it's an enormous burden. It increases my workload and is rather unfair, because if it wasn't for what the committees had done, I could have been presenting substantive amendments here at report stage. That is my right as a member of Parliament and not one of the three big parties. But that right, I have very few rights as a member of Parliament with one seat for the Green Party, but one of those rights was to be able to make substantive amendments at report stage. And my rights have been subsumed into what, as I said, was done first by the Conservative government, now by the Liberals, to say that I have an opportunity to present amendments at not at report stage. I have an opportunity to present amendments in clause by clause in committee, although I'm not a member of the committee, don't have a right to vote, but get a chance to speak to my amendments. Well, it was under that committee motion that I was able to present 46 amendments and participated vigorously in clause by clause of Bill C-75. And I have to say it was a very discouraging process, as very few amendments from opposition parties were accepted. Most of my amendments went directly to testimony from many witnesses who wanted to see the bill improved. And I'm disappointed that none of my 46 amendments made it through. I should say that some of the worst parts of Bill C-75 were changed on the basis of government-proposed amendments. One of the ones that had worried me a great deal was the idea that evidence in a criminal trial from the police could come in the form of a written statement without proffering the police officer in question for cross-examination. That was amended so that they cannot use what they call routine police evidence without having someone put forward to be cross-examined. There was also the repeal of the Vagrancy Act and repeal of the law about keeping a common bawdy house. But many other sections of this bill cry out for further amendment. So at this point, I want to highlight those sections that really need to be amended and hope that when the bill leaves this place, as it inevitably will, we're at report stage, third reading will come in short order, we're already under time allocation, that when this bill gets to the Senate, that at the other place will pass amendments that are needed. Because it's quite clear that this bill in some key areas does the opposite of what the government has promised, particularly in relation to disadvantaged people, particularly in relation to the status of Indigenous peoples within our prisons, particularly in relation to access to justice and fairness, which has actually been worsened in this bill. It's not something I expected to be standing up and saying at report stage, but there it is. It's massively disappointing, and I do hope that the Senate will improve it. Now, one of the things that was done, and I'm not sure if it was the best solution, but it was clearly a response to the Stanley case, where where, of course, it was a massive sense of a miscarriage of justice. But the courts, after that, when you have a jury, you're supposed to have a jury of your peers. And if you're an Indigenous youth and your jury is entirely Caucasian, it's not exactly a jury of your peers. One of the reasons that this happens was the use of peremptory challenges. So I do appreciate the effort in Bill C-75 to eliminate peremptory challenges. But I do want to go over the ways, Mr. Speaker, in which this bill actually takes us backwards. The effort here, of course, as many other members have pointed out, honourable members have pointed out, this bill is a direct response to the Jordan decision of the Supreme Court of Canada in 2016, in which the delays could be so profound that the case could not proceed. So it was very clear that the new trial timelines for provincial courts of 18 months and of 30 months for Superior Court, I think all Canadians feel the same sense of concern. No one wants someone to be freed who, at this point, of course, still has the presumption of innocence because they haven't gone through their court case. But if the evidence was good enough and the prosecutors brought that person forward, the idea that they're just let out of jail because the trial times and the processing of that person took too long, that offends our sense of justice. I think it offends all of our sense of justice. So the Government of Canada, the Parliament of Canada, was given a very quick, I would have to say, jab towards justice by the Supreme Court of Canada. But have we gotten it right? Now, in the effort of speeding up trials, I'll mention one thing first, which is the issue of eliminating preliminary inquiries. There was a great deal of evidence before our committee that we didn't have, and the Government of Canada did not have, and Justice Department did not happen to have good data to tell us that preliminary inquiries were a source of great delay. In fact, and I just want to quote from one of the legal experts who did testify before the committee, Mr. Trudel, who is the current chair of the Canadian Council of Criminal Defense Lawyers. And he described preliminary inquiries like this, quote, "They're like x-rays before an operation." Well, that is a very useful thing to have, and they don't happen all the time. But when you remove them without good evidence as to why you're removing them, you could, in fact, end up having innocent people convicted. And in fact, Bill Trudel, who I just quoted from the Canadian Council of Criminal Defense Lawyers, has said, as difficult as it is for him to say it, he thinks more innocent people will be convicted because we've taken out preliminary inquiries without quite having the evidence that that was a good thing to do to speed up trials. We also have the problem that having changed the range of sentencing, we've heard a lot from my friends in the Conservative caucus about the question of hybridization, but the effect of C-75 is also to increase the sentencing for a summary conviction from 6 months to 2 years. They've also added in C-75 provisions that I don't think were thoroughly thought through about the use of agents. Now, to give a better sense of agents, and this goes to the question of access to justice. Suppose you're not quite poor enough to get a legal aid lawyer, but you're trying to navigate the legal system and you can't afford a lawyer. And in many of those cases, for a very long time, criminal defendants have had the benefit, particularly if they're low income, they've had the benefit of law school clinics, young lawyers in training, student lawyers working as a clinic to provide legal services to people charged with lesser offenses. Now, if we don't amend this, now of course it's too late to amend, here we are at report stage, we needed to amend this. I hope the other place will amend this to ensure access to legal aid clinics out of law schools in order to be able to get help to marginalized groups navigating the legal system. This, I think, is an unintended consequence. I'm certain that people in the Department of Justice didn't ponder this and say, oh, one of our problems is too many poor people are getting help from law students. That wasn't a problem that wanted solving. That was a very good and ongoing process, which has been, I think, recklessly compromised in this bill. And I have to hope that when it gets to the other place, we can fix this and make sure that by the definition of agents, we exclude law students and law schools running clinics. There are other aspects of this bill where we just failed altogether to deal with the issue of the disproportionate number of Indigenous people behind bars. We've taken into some aspects of taking things into account, but one of my amendments that I really regret wasn't accepted was we have no definition of vulnerable populations. And a lot of the evidence that came before the Justice Committee suggested we needed such a definition. I tried one. It failed. Maybe the other place can try again. I know my time is up, Mr. Speaker. I hope that Bill C-75 will see more improvements in the other place before it becomes law. Thank you.
Questions and comments? Question commentaire, the honourable member for Parkdale High Park.
Thank you, and I thank the member for Saanich Gulf Islands for her contribution to today's debate and for all of the debates in this chamber, and for her contributions at the committee deliberations. A couple of comments and then a question, Mr. Speaker. The member commented on the lack of amendments that were accepted. Almost 50 amendments were accepted at the committee stage, including several from members of Her Majesty's official opposition. With respect to paralegals and agents, there was a significant amendment that was made to the criminal code at the committee stage that addresses the very problem that was outlined by the member opposite in respect of ensuring that law societies and provincial regulatory bodies would indeed be able to empower agents to continue to appear on summary conviction offences, even ones that carry a penalty of up to 2 years. The important point about peremptories, I think, needs to be re-emphasized is that peremptory challenges were advocated, a change to peremptories was advocated for by Jonathan Rudin, a distinguished member of the bar who deals with Aboriginal clients and Indigenous clients, who said this indeed will make a substantial impact on ensuring that you don't have homogenous juries dealing with racialized accused. But what I would ask the member opposite, and my question is this, is that for her comment on, with respect to the changes to administration of justice offences, what we've sought to do is ensure that Indigenous accused and other overrepresented communities are not overly penalized and recriminalized for simply violating something like breaching a curfew or breaching bail. That is being taken out of the criminal procedure, put into the administrative procedure. Is that a step in the right direction from the member's perspective?
The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. And to my honourable colleague, first briefly on the other point, I do recognize the amendment, but it kicks it to the provinces to act, and the question is, will they act to deal with the question of making sure law students can participate in the hearings? Yeah, the bail issues and not recriminalizing people for things over which they really don't have control goes directly back to the Supreme Court of Canada decision in R versus Morales. I think we've done a partial job in C-75. I think we could have done more. As my honourable colleague will remember, a number of my amendments went to that question of making sure that we really thought through the levels of conditions of addictions or poverty that would make it virtually impossible to meet certain bail provisions. I think we could have done more, but I agree there are steps in the right direction in C-75 to respond to R versus Morales.
Questions and comments? The honourable member for Sarnia-Lambton.
Thank you, Mr. Speaker, and I'd like to thank the member for Saanich Gulf Islands for her speech and for her very hard work. She's on her own coming to all these different committees with all these different bills that come before, and she does do a thorough job of bringing amendments. I'm specifically interested to understand in all of the amendments that she brought, which are the ones that she considers to be the most important that should be included when it goes to the other place.
The honourable member for Saanich Gulf Islands.
I'm so grateful to my friend for Sarnia-Lambton for those generous comments. I'll go back to the amendment about defining a vulnerable population. I think that would be very helpful. And I think there are a series of amendments, and not to quote them all, but the ones that leave a lot of discretion to police officers to decide which track a potential accused is going to go to. The question of whether or not our police officers who are wonderful professionals, but do they have the training to assess the socioeconomic conditions, issues of trauma? I think it's putting too much on police. That there should have been a provision to ensure that was left to prosecutors, the justice system, with the advice of people in what we might think of as the caring fields.
Questions and comments? The honourable member for St. Albert, Edmonton. Very briefly, please.
Mr. Speaker, and I thank the member for Saanich Gulf Islands for her contribution to Bill C-75, and she did make reference to the limitation of preliminary inquiries only to those cases where the maximum sentence is life behind bars. Now, she's quite right that the evidence before the committee overwhelmingly was that it will not reduce delay, that in fact it might increase delay because preliminary inquiries help weed out cases, particularly weak cases. But in addition to that, I was wondering if she could speak to this life criteria. It seems to be quite arbitrary, because there are certain offenses where the maximum sentence may be life and others where it's not, but in terms of the sentencing guidelines or the case law, one would expect a similar sentence to be imposed, but yet in one case a preliminary inquiry would be available, in the other case it wouldn't. It seems not to make a lot of sense.
The honourable member for Saanich Gulf Islands in 30 seconds or less,
Well, I
please.
appreciate my friend from St. Albert, Edmonton, bringing us back to the question of preliminary inquiries. There is that question around whether that is a proper sentencing threshold, but it allows me to raise another thing, another point about how the bill discriminates against marginalized people. Someone who's got a lot of money, to put it in brief, without a preliminary inquiry, can hire a private detective and try to figure out what were the facts that they would have been able to discern had there been a preliminary inquiry. They can go out and get a private detective and find out a lot about the other facts of the case. But someone without income, who's not going to be able to hire a private detective, will have unequal access to justice as a result of eliminating the preliminary inquiry when they're not sentenced to an offense that has a sentence up to life.